ruling. The Court of Appeal has declared that the Deputy Chief Justice, Philomena Mwilu, lacked the constitutional authority to appoint a bench to hear petitions challenging the impeachment of former Deputy President Rigathi Gachagua. The decision underscores the exclusive role of the Chief Justice in such judicial appointments as stipulated in the Constitution. The ruling not only impacts the ongoing legal proceedings, but also raises critical questions about judicial authority and constitutional interpretation. So joining us tonight to provide expert insight on the impact of this ruling is constitutional lawyer Kibe Mungai. Kibe, many thanks for speaking to NTV tonight. Let's perhaps begin at the very beginning. What caused the Court of Appeal to issue this ruling in the first place?
What caused the Court of Appeal to issue this ruling is that immediately after the Senate impeached Deputy President Honorable Rigathi Gachagua, there was a number of cases were filed. And in those cases that were filed, and the following day, first of all, the Parliament, within 4 hours, they received the nomination of Honorable Kindiki, and they approved the nomination. Right. Then, but before now the swearing in could be carried out, a number of cases were filed. One of those cases in Kerugoya, they issued, and another case elsewhere, they issued in Nairobi, they issued orders to one of them to stop the decision of the Senate, and number two, to stop the swearing in of Honorable Kindiki. Now, as a result of that, when the matters came up for hearing, the Chief Justice was not in the country. So the Deputy Chief Justice, Honorable Mwilu, appointed 3 judges. Those 3 judges were to hear those petitions. The appointments were made on Saturday, but we went to court the coming Tuesday. One of the issues when we went to court was to raise the authority of the Deputy Chief Justice to appoint judges, because the Constitution, Article 165(4) of the Constitution says that where a case, a petition, raises substantial questions of law, and a judge of the High Court has certified that, then the Chief Justice shall appoint a bench of either 3 or more judges to decide the case. Now, the Article 165(4) of the Constitution does not share that power with the Deputy Chief Justice. It is an exclusive function of the Chief Justice, or a person acting as Chief Justice, for purposes of being able to exercise that power. So we argued the case. That bench held that they were lawfully appointed by the Deputy Chief Justice. Right. That is what triggered the appeal that went to the Court of Appeal, and the Court of Appeal now agreed with the petitioners and with Rigathi Gachagua that the Deputy Chief Justice does not have that power, and because he does not have those powers, it effectively means they wrongfully had 3 of those cases because they had not been properly appointed. Of course, that is where there is a huge significance of what that means. And of course, the Chief Justice now has been told, you need directed to empanel a bench. When you empanel that bench, that's why I'm saying that's where the significant point lies. The first issue of that bench would obviously be to hear afresh the cases that were heard by those 3 judges without authority. Okay, and then that was my next question, because the Court of Appeal's directive is that the case should go back to the Chief Justice, who should appoint a new bench within 14 days. So how will this affect the timeline and the outcome of the petitions challenging Gachagua's impeachment? No, now there is no hurry. You know, hurry was only when Parliament and the President were dealing with these issues. The court processes are supposed to be procedural, to ensure that in every step of the way, what is required by the Constitution, other rules or in the statute, and the rules of natural justice are observed. They were not observed with regard to the decision that was caused by the Deputy Chief Justice. Right. And therefore, there is no problem with the timelines. The critical bit would have to be the Court of Appeal appreciated the fact that this is a matter that needs to be disposed of one way or the other. And that is why within 14 days, we expect that the Chief Justice will empanel a bench to rehear, fresh hearing of those applications. The significant point here before we lose it is that because there were orders in Kerugoya barring the swearing in of Deputy President Kindiki, it effectively means that you go back to the position as it was before the declaration was made. That is that there are orders barring Honorable Kindiki from being sworn into office. That is the basis upon which those applications will be heard for our decisions to be made one way or the other. This brings to fore, is it therefore possible that the Deputy Chief Justice is in office lawfully? The answer from where we came from, because the courts have said severally, if you do something that you had no legal capacity to do, that thing is null and void. It is as if it never happened. And therefore, it is the position that as we speak today, and as a result of these decisions, the Deputy President may be in office de facto, that it is a reality, he is discharging certain functions. But under the law, he'll have to wait for the fresh hearing of those decisions to confirm whether he is in office. Because remember, immediately after that decision was made, what happened is that there was a ruling on 30th of October. The ruling of 30th of October, I believe it could have been 31st, basically said that you set aside the orders that were given by the High Court in Kerugoya and gave the green light for Deputy President Kindiki to be sworn in. Now that we have reversed the position and gone to the position where there are orders, it is our position, and we shall be taking it to court very soon as we have that bench, to be able to say that probably Kindiki, until the illegality of whether he's in office lawfully has been settled, he should stop carrying himself, passing himself off as a deputy president.
All right, we don't have too much time, Kibe. Finally, the Court of Appeal's ruling is likely to set a precedent for future cases, especially where the Deputy Chief Justice has played a key role in the appointment of judges or the administration of judicial processes. How do you foresee these future constitutional challenges arising from this decision?
There are none. This is a matter that has previously been decided by the court, and the main issue is that the court said the powers of the Chief Justice to empanel judges on substantial questions of law is not an administrative power. It is a substantive power where he does as the Chief Judge. Remember, there is only one Chief Judge, and that Chief Judge has express authority to be able to make those appointments. So there is no cause for alarm, because as long as we have a Chief Justice, then there's nothing to worry about.
All right, many thanks. That is a constitutional lawyer, Kibe Mungai, giving us context into that landmark ruling by the Court of Appeal there, declaring that Deputy Chief Justice Philomena Mwilu lacked constitutional authority to appoint a bench to hear petitions challenging the impeachment of former Deputy President Rigathi Gachagua. Let's take a break here on NTV Weekend Edition. Much more still to come on the other side. Just stay with us.